Welcome to episode 41 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Enbridge Energy LP versus Nessel. The case was decided April 22nd, 2026. And as always, we'll begin with the syllabus. Petitioners, collectively Enbridge, own and operate Line 5, a 645-mile petroleum pipeline, 4 miles of which traverse the Straits of Mackinac, pursuant to a 1953 easement granted to Enbridge's predecessor by the state of Michigan. On June 27, 2019, the Michigan Attorney General filed suit in Michigan State Court seeking to halt Enbridge's operation of Line 5 by having the 1953 easement declared void and Enbridge's continuing operations declared unlawful. Enbridge was served with the complaint on July 12, 2019. Rather than removing the case to federal court within the 30-day deadline required by 28 U.S.C. Section 1446b1, Enbridge litigated in state court for months. In November 2020, more than a year after Enbridge's removal deadline had lapsed, the Michigan governor issued a notice revoking the 1953 easement and filed a separate lawsuit in state court against Enbridge. In that suit, unlike in the Attorney General's suit, Enbridge timely removed to federal court, and the parties agreed to hold the Attorney General's case in abeyance while federal proceedings progressed. After the district court denied the governor's motion to remand, finding federal question jurisdiction satisfied, the governor voluntarily dismissed her lawsuit. On December 15, 2021, 887 days after receiving the Attorney General's complaint, Enbridge removed this action to federal court. The Attorney General moved to remand, arguing that removal was untimely under Section 1446b's 30-day deadline. The district court denied the motion, holding that equitable principles justified excusing Enbridge's untimely removal and certified its order for interlocutory appeal. The Sixth Circuit reversed, holding that although Section 1446b1's deadline is non-jurisdictional, several features of Section 1446b1 and the overall removal scheme rebutted any presumption of equitable tolling. Thus, the lawsuit had to be remanded to the Michigan State Court. This court granted certiorari to resolve a divide among the courts of appeals on whether Section 1446b1 is subject to equitable tolling. Held. Because Section 1446b1's text, structure, and context are inconsistent with equitable tolling, Enbridge's removal was untimely. Part A. The fact that the 30-day removal deadline in Section 1446b1 is non-jurisdictional does not automatically render it subject to equitable tolling. While jurisdictional requirements cannot be waived or forfeited and do not allow for equitable exceptions, the mere fact that a time limit lacks jurisdictional force does not render it malleable in every respect. Some non-jurisdictional rules remain mandatory and are not susceptible of equitable tolling. This court need not decide whether Section 1446b1 qualifies as a statute of limitations subject to a presumption of equitable tolling, because even if the presumption applies, it can be rebutted if there is good reason to believe that Congress did not want the equitable tolling doctrine to apply. Here, the text, structure, and context of Section 1446b1 demonstrate that Congress did not want the 30-day deadline to be equitably tolled. The text of Section 1446b1 speaks in strict mandatory terms, requiring that a notice of removal shall be filed within 30 days. Although such mandatory language alone is not sufficient to rebut the presumption of equitable tolling, it is consistent with treating the deadline as mandatory and not subject to equitable tolling. More important and decisive here is Section 1446b1's structure. An explicit listing of exceptions set forth in a detailed manner strongly indicates that Congress did not intend courts to read other unmentioned open-ended equitable exceptions into the statute. That is especially so when the specific exceptions already reflect equitable considerations. There are several such exceptions here. First, and functioning much like an equitable discovery rule, Section 1446b(3) provides an extension when a case at first appears unremovable, but it is later ascertained that the case is or has become removable. Congress thus has already effectively allowed for equitable tolling in one respect, but not others. Section 1446c(1) also imposes a 1-year cap on this rule in diversity cases, but creates an exception if a plaintiff acted in bad faith, specifically accounting for equitable factors in a way that would be superfluous if Section 1446b(1) already provided for equitable tolling more broadly. Exceptions to the 30-day deadline outside of Section 1446 confirm the point. For actions against foreign states, Congress specifically allowed the time limitations of Section 1446b to be enlarged at any time for cause shown, Section 1441d. Similar provisions exist for certain intellectual property cases, see Section 1454b2, and cases involving fatal accidents, see Section 1441e1. Each provision explicitly incorporates Section 1446b(1)'s time limit, but modifies it to allow equitable, case-specific exceptions that would be inexplicable and unnecessary if Congress already understood Section 1446b(1) to contain a cross-cutting equitable tolling rule. Congress's treatment of removal in criminal proceedings provides additional confirmation. Under Section 1455b(1), a criminal defendant must generally remove within 30 days after arraignment, but for good cause shown, a court may grant leave to file at a later time. For civil cases, by contrast, Congress did not provide courts with a similar general power to extend the 30-day removal deadline. The nature of the subject matter here further underscores the unavailability of equitable tolling. The federal civil removal statutes have an obvious concern with efficiency, and a general interest in avoiding prolonged litigation on threshold non-merits questions. Allowing equitable tolling would undermine Congress's manifest interest in resolving threshold removal questions early and conclusively, generating uncertainty and risking significant waste of resources. Part B. Enbridge's counterarguments are not persuasive. Enbridge's argument that rebutting the presumption of equitable tolling requires the clearest command from Congress conflicts with the court's repeated holdings that the presumption is rebutted where Congress's choice is evident, where tolling would be inconsistent with the text of the relevant statute, and where there is good reason to believe that Congress did not want equitable tolling to apply. None of these decisions required the clearest command that Enbridge demands. Enbridge's attempts to characterize Section 1446b(3) as an accrual rule rather than an exception does not account for the separate bad faith exception in Section 1446c(1) or the many other provisions outside Section 1446 that expressly allow courts to toll Section 1446b(1)'s deadline for cause shown. The fact that these provisions are located outside of Section 1446 itself does not diminish their force. Courts must consider equitable tollings in congruence with the statutory scheme overall. Enbridge cannot identify any sensible reason why Congress would have adopted so many express, specific equitable exceptions to Section 1446b(1) if equitable tolling was already available for belated removals across the board. Finally, Enbridge's argument based on Section 1447c's treatment of defects in subject matter jurisdiction does not support equitable tolling. Justice Sotomayor delivered the opinion for a unanimous court. Under 28 U.S.C. Section 1446b(1), a party sued in state court who prefers to proceed in federal court generally has 30 days after receiving notice of the state court action to remove the lawsuit to federal court if there are grounds for doing so. In this case, petitioners, collectively Enbridge, unquestionably did not meet Section 1446b(1)'s 30-day deadline, instead waiting 887 days after being served with the Michigan Attorney General's state court complaint before removing the case to federal court. Enbridge argues that the district court nevertheless had equitable discretion to toll Section 1446b(1)'s deadline and excuse this late filing. This court disagrees. Because Section 1446b1's text, structure, and context are inconsistent with equitable tolling, Enbridge's removal was untimely and remand to the Michigan State Court is required. Part 1, Section A. The right to remove a lawsuit from state to federal court is entirely a creature of statute, and a suit commenced in a state court must remain there until cause is shown for its transfer under some act of Congress. Congress provided one such basis for removal in Section 1441A, which authorizes removal if a civil action brought in a state court is one over which the district courts of the United States have original jurisdiction. For example, if a plaintiff sues in state court bringing federal claims, or if the plaintiff and defendant are from different states and there is a sufficient amount in controversy, the defendant may remove to federal court. For defendants seeking to remove under Section 1441A, the procedures for doing so are largely set forth in Section 1446. Key here as to timing, the notice of removal of a civil action or proceeding shall be filed within 30 days after the receipt of the initial pleading in that action, or within 30 days after the service of summons upon the defendant, whichever period is shorter. Section 1446b. This 30-day default rule is subject to several exceptions in Section 1446 and elsewhere. Section 1446b3, for instance, extends the 30-day deadline if an initial pleading did not provide a basis for removal, but it is later ascertained that the case is one which is or has become removable. As detailed below, this rule in turn is subject to an exception which itself has yet another exception. Outside of Section 1446 itself, Congress has also allowed later removal for cause shown in specific scenarios. After a case is removed, any motion to remand the case to state court must be filed within 30 days of the notice of removal. An order remanding a case generally is not reviewable on appeal or otherwise. Section B. Enbridge owns and operates the 645-mile-long Line 5 pipeline, which runs from northwestern Wisconsin through Michigan and into Canada. Footnote 1. Petitioners are Enbridge Energy LP, Enbridge Energy Co. Inc., and Enbridge Energy Partners LP. For simplicity, the court refers to them together as Enbridge. Carrying on. Line 5 is part of a pipeline network that transports petroleum products to refineries across the Midwestern United States, Ontario, and Quebec. Between Michigan's upper and lower peninsulas, a 4-mile strip of Line 5 traverses the Straits of Mackinac pursuant to a 1953 easement granted to Enbridge's predecessor by the state of Michigan, which has long owned the strait's bottomlands. On June 27, 2019, the Michigan Attorney General filed this lawsuit in Michigan State Court seeking to halt Enbridge's operation of Line 5. She alleged that the 1953 easement is void and that Enbridge's operations violate Michigan law given the risk of an oil spill from the pipeline. On July 12, 2019, the Attorney General served Enbridge with a complaint. Over the following months, Enbridge did not remove the case to federal court, and instead briefed cross motions for summary disposition and participated in oral argument on those motions, all in state court. Enbridge argued, among other things, that the state law claims against it were preempted by federal law. On November 13, 2020, more than a year after Enbridge's 30-day deadline to remove had lapsed, Michigan Governor Gretchen Whitmer issued a notice of revocation of the 1953 easement, calling for Line 5 to be shut down. At the same time, the governor filed a separate lawsuit in Michigan State Court against Enbridge to enforce the notice, bringing state law claims very similar to those in the Attorney General's lawsuit. Instead of litigating the governor's suit in state court, Enbridge timely removed that action to federal court, arguing that the federal district court had jurisdiction under Section 1331 because the case involved a substantial federal question. Enbridge did not remove the Attorney General's suit at that time. Instead, the parties agreed to hold the Attorney General's case, that is, this case, in abeyance while federal proceedings progressed in the governor's suit. The governor moved to remand her case to state court, arguing that the case did not raise a significant federal issue. Soon after, the Government of Canada submitted amicus filings arguing that shutting down Line 5 would implicate a 1977 treaty between Canada and the United States and impair foreign relations between the two countries. On November 16, 2021, the district court denied the governor's motion to remand, concluding that federal question jurisdiction was satisfied because the claims necessarily implicated substantial federal questions under two federal statutes and the 1977 treaty. The governor voluntarily dismissed her lawsuit not long after that ruling. Footnote 2. Similar issues remain pending in another federal action. In November 2020, Enbridge sued the governor seeking affirmative relief, and in December 2025, the district court granted summary judgment to Enbridge, concluding that the governor's efforts to shut down Line 5 were preempted. Carrying on. On December 15, 2021, following the district court's favorable remand ruling in the governor's suit, Enbridge removed this action to federal court. At that point, 887 days had lapsed from when Enbridge received the Attorney General's complaint. The Attorney General moved to remand, arguing, as relevant here, that removal was untimely under Section 1446B's 30-day deadline. The district court denied the motion, holding that equitable principles justified excusing Enbridge's untimely removal. It then certified its order denying remand for interlocutory appeal under Section 1292B. After accepting the interlocutory appeal, the Sixth Circuit reversed. Enbridge, the circuit held, unquestionably missed the 30-day removal deadline. As for the district court's conclusion that Section 1446B1's deadline should be equitably tolled, the circuit held that although statutes of limitations are presumptively subject to such tolling, several features of Section 1446B1 and the overall removal scheme rebutted that presumption. Section 1446B1 thus could not be equitably tolled, and the lawsuit had to be remanded to Michigan State Court. Enbridge filed a timely petition for a writ of certiorari, seeking review of the Sixth Circuit's holding that Section 1446B is not subject to equitable tolling. Other courts of appeals have held that equitable tolling is available under Section 1446B1 in at least some circumstances. This court granted certiorari to resolve the divide among the courts of appeals. Part 2. Enbridge's argument proceeds in 3 steps, each critical to prevailing here. First, it contends that Section 1446B1's 30-day removal deadline is not jurisdictional. Second, because the deadline is non-jurisdictional, Enbridge argues that it is presumptively subject to equitable tolling. Third, according to Enbridge, nothing rebuts the presumption that this deadline can be equitably tolled. At the first step, there is rightly no dispute. No one contends that Section 1446B1 is jurisdictional, given that it does not expressly refer to subject matter jurisdiction or speak in jurisdictional terms. That much is crucial for Enbridge's case, as jurisdictional requirements cannot be waived or forfeited, must be raised by courts sua sponte, and as relevant to this case, do not allow for equitable exceptions. The mere fact that a time limit lacks jurisdictional force, however, does not render it malleable in every respect. Some non-jurisdictional rules remain mandatory and are not susceptible of the equitable approach that Enbridge urges. That brings us to steps 2 and 3 in Enbridge's argument. The Attorney General argues that at each step, Enbridge confronts an independent reason why Section 1446B1, though non-jurisdictional, is not subject to equitable tolling. First, she disagrees that any presumption of equitable tolling applies to Section 1446B1. This court has only applied the presumption of equitable tolling to statutes of limitations. According to the Attorney General, Section 1446B1 is not a statute of limitations because it does not extinguish a tardy claim, the function of a statute of limitations, and instead addresses a forum issue that arises only after a claim for relief has been brought. Second, the Attorney General argues that even if Section 1446B1 is a statute of limitations to which the presumption of equitable tolling applies, the presumption is rebutted here because such tolling conflicts with Section 1446B1's text, structure, and context. As in prior cases, the court need not parse whether Section 1446b1 qualifies as a statute of limitations subject to a presumption of equitable tolling, because the result, even if the presumption applies, is straightforward. The presumption is rebutted if there is good reason to believe that Congress did not want the equitable tolling doctrine to apply. Here, the kinds of evidence the court generally considers on this question shows that Congress did not want Section 1446b1 to be equitably tolled. Starting with the text of Section 1446b1, this provision speaks in strict, mandatory terms. It requires that a notice of removal shall be filed within 30 days of the defendant receiving either a complaint or summons, whichever period is shorter. To be sure, this kind of mandatory language is not sufficient on its own to rebut the presumption of equitable tolling. The strict parsing of Section 1446b1, however, is at least consistent with treating its deadline as mandatory and not subject to equitable tolling. More important and decisive here is Section 1446b1's structure. This court has repeatedly held that an explicit listing of exceptions set forth in a detailed manner strongly indicates that Congress did not intend courts to read other unmentioned open-ended equitable exceptions into the statute that it wrote. That is because it would be inconsistent with a comprehensive scheme that includes a default deadline and several exceptions to extend the deadline still further through the doctrine of equitable tolling, outside of those specified exceptions. This structural inference is heightened, moreover, if the specific exceptions at issue already reflect equitable considerations. That is exactly the case here. Within Section 1446b itself, Congress provided that the ordinary 30-day deadline does not apply when a case at first appears unremovable, but a later pleading, motion, order, or other paper reveals that it is or has become removable. Section 1446b3. In that case, the defendant has another 30 days to remove from receipt of the paper from which it may first be ascertained that the case is removable. This extension is limited, however, if the basis for removal is diversity of citizenship. Such a case may not be removed under subsection B3 more than 1 year after commencement of the action unless the district court finds that the plaintiff has acted in bad faith in order to prevent a defendant from removing the action. Section 1446c1. This highly detailed scheme matters for at least 2 reasons. First, the ascertainment provision in Section 1446b3 functions much like a discovery rule, giving defendants extra time to remove after the date on which they learned or should have learned that a case was removable. In doing so, Congress has already effectively allowed for equitable tolling in this one respect but not others, which cuts against the availability of broader tolling. Second, in creating the bad faith exception to Section 1446c1's 1-year bar in diversity cases, Congress specifically accounted for equitable factors by providing additional time for removal in a way that would be superfluous if Section 1446b1 already broadly provided for equitable tolling in all cases. Exceptions to Section 1446b1's 30-day deadline outside of Section 1446 drive home the point. For actions against foreign states, Congress specifically allowed the time limitations of Section 1446 to be enlarged at any time for cause shown, Section 1441d. So too for actions involving certain intellectual property rights. See Section 1454b2. For certain cases involving fatal accidents, removal generally shall be made in accordance with Section 1446, except that, as to timing, an action may be removed at a later time with leave of the district court. Section 1441e1. Each of these provisions explicitly incorporates Section 1446b1's time limit, but modifies it to allow equitable, case-specific exceptions. Each provision would be inexplicable and unnecessary, however, if Congress already understood Section 1446b1 to contain a cross-cutting rule allowing equitable tolling. Stepping beyond the removal of civil cases, Congress's treatment of removal in criminal proceedings provides additional confirmation that Congress did not want equitable tolling under Section 1446b1. Under Section 1455b1, a criminal defendant with a removable case must generally remove within 30 days after the arraignment in the state court. But for good cause shown, a court may grant the defendant or defendants leave to file the notice at a later time. In criminal cases, Congress thus did grant federal courts a broad, generally applicable power to allow late removals. For civil cases, by contrast, Congress did not provide courts with a similar general power to extend the 30-day removal deadline. Instead, through the limited exceptions discussed above, Congress specified the cases in which it wanted to authorize equitable tolling. Enbridge's position would eliminate the variation between these two removal contexts, but when Congress includes particular language in one section of a statute but omits it from a neighbor, we generally understand that difference in language to convey a difference in meaning. Finally, and to garnish an already solid argument, the nature of the subject matter here underscores the unavailability of equitable tolling. The federal civil removal statutes have an obvious concern with efficiency and a general interest in avoiding prolonged litigation on threshold non-merits questions. That is reflected not only in the short deadline for removal itself, but also in the strict 30-day deadline for seeking remand of a removed action, Section 1447C, and the default rule that remand orders are not appealable, Section 1447D. Allowing equitable tolling of Section 1446b1's deadline would undermine Congress's manifest interest in resolving threshold removal questions early and conclusively. Under the rule the court adopts today, plaintiffs that sue in state court usually can be confident that after Section 1446b1's deadline has lapsed, the forum question has been put to rest and the case will proceed in the chosen court. Under the rule Enbridge favors, to the contrary, the possibility of a late removal would hang over a case, generating uncertainty and risking significant waste of resources in one forum before a possible belated removal to another. Because Enbridge's approach would upset the balance struck by Congress in the removal statutes, these underlying concerns provide yet another reason to conclude that equitable tolling is not available under Section 1446b1. Part 3. Enbridge's counterarguments are not persuasive. It starts by attempting to raise the bar for rebutting the presumption of equitable tolling. In its view, it is not enough to show that tolling is inconsistent with the overall statutory scheme. The question is instead whether Congress has provided the clearest command that equitable tolling should not apply. This court, however, has never applied such a requirement in this context, and doing so would conflict with the court's repeated holdings that the presumption has been rebutted where Congress's choice is evident, where tolling would be inconsistent with the text of the relevant statute, and where there is good reason to believe that Congress did not want the equitable tolling doctrine to apply. None of these decisions required the clearest command that Enbridge demands. They simply looked to text, structure, and context and asked if there were good reasons to conclude that tolling should not be available. Footnote 3. Enbridge relies heavily on this court's use of the clearest command language in Holland versus Florida. But Holland used that language to explain why the presumption was reinforced in that case. The court will not read a statute to displace the equitable principles that have traditionally governed the substantive law of habeas corpus, absent the clearest command. That is a different issue than displacing the presumption of equitable tolling. Carrying on. As discussed above, such reasons are present here. On the text of Section 1446b1, Enbridge argues that the 30-day deadline is short and focused on litigants' conduct, not court's authority, which, according to Enbridge, makes it akin to other provisions the court has held subject to equitable tolling. This court, however, has found other deadlines that speak at least in part to a litigant's conduct, and with even shorter deadlines, not to be subject to equitable tolling when surrounding context led to that conclusion. See, for example, Brockamp, claim had to be filed by the taxpayer within certain periods. Compare nutraceutical, similar, with 14-day window. Footnote 4. Enbridge tries to distinguish Brockamp on the ground that it set forth its deadline in a highly detailed technical manner. It is unclear, however, that 28 U.S.C. Section 1446b1, with its two alternative deadlines, choice of whichever period is shorter and many exceptions is meaningfully less detailed than the statute in Brockamp. Carrying on. Seeking to discount the many exceptions to Section 1446b1's deadline, Enbridge disputes whether they are really exceptions at all. As to Section 1446b3, which applies to later ascertained removability, Enbridge argues it is more akin to an accrual rule for a limitations period, which this court has distinguished from a true exception. Even if so, however, that would not account for the separate bad faith exception to the 1-year deadline for diversity cases in Section 1446c1. Nor does Enbridge's rejoinder account for the many other provisions outside of Section 1446 expressly allowing courts to toll Section 1446b1's 30-day deadline for cause shown and the like. Enbridge labels these as comprehensive legislation targeting a particular area for reform, not exceptions to Section 1446b. The problem is that, in the most important respect, these statutes are not comprehensive. They do not set their own deadlines, but rely on Section 1446b1 and modify it. Critically, they often do so precisely to allow consideration of the very same equitable factors that, on Enbridge's theory, are already built into Section 1446b1. Enbridge also suggests that because these exceptions are located outside of Section 1446 itself, they should carry less force. The court, however, has already disapproved of such laser focus on a single provision in isolation. Arellano. Instead, courts must consider equitable tollings in congruence with the statutory scheme overall. The fact that the timing scheme here is set forth in provisions that extend beyond Section 1446 is not a meaningful difference from Arellano. Enbridge also attempts to distinguish this case from Arellano on the ground that the timing rule at issue in Arellano had 16 distinct exceptions while Section 1446b1 has fewer, and points out that this court has found equitable tolling to apply even when a deadline has an explicit exception. Enbridge is correct on the numbers, but this inquiry is not a mere counting exercise. In Holland, the key point was not that there was only one exception. It was that the exception at issue, tolling the time for seeking federal habeas relief while an application for state post-conviction relief is pending, was easily explained by a special need for an express provision accounting for state court litigation, which undermined any inference that Congress did not intend for equitable tolling more broadly to apply. Here, to the contrary, Enbridge cannot identify any sensible reason why Congress would have adopted so many express, specific equitable exceptions to Section 1446b1 if equitable tolling was already available for belated removals across the board. Finally, Enbridge points to Section 1447c's 30-day deadline for motions to remand, which does not apply if a court lacks subject matter jurisdiction. As Enbridge sees it, Congress's requirement of remand even outside of the 30-day deadline for lack of subject matter jurisdiction, but not for other defects like untimeliness, suggests that Congress intended to treat untimeliness less harshly than the lack of jurisdiction, including by allowing equitable tolling. Enbridge's conclusion does not follow from its premises. Section 1447c reflects the unique stringency that applies to jurisdictional rules, which cannot be waived or forfeited. As explained above, however, not all non-jurisdictional rules can be equitably tolled. The fact that Section 1447c requires remand at any time for jurisdictional defects but not for non-jurisdictional defects like untimeliness, therefore in no way implies the availability of equitable tolling. Footnote 5. The court resolves only the applicability of equitable tolling to Section 1446b1 and does not resolve the applicability of other equitable doctrines like waiver, forfeiture, and estoppel. Carrying on. Part 4. Assuming Section 1446b1 is a statute of limitations and is therefore subject to the presumption of equitable tolling, the statute's text, structure, and surrounding context provide good reason to find the presumption rebutted. Accordingly, Section 1446b1's 30-day deadline cannot be equitably tolled. The Court of Appeals therefore correctly held that Enbridge's notice of removal was untimely and that this action must be remanded to the Michigan State Court. The judgment of the Court of Appeals is affirmed. It is so ordered. And that is it for the opinions of the justices. So now we'll get into the opinions of the host. And as you might expect, given that this was a unanimous decision by the court, without even so much as a concurrence from another justice to add anything or, express displeasure with a part of the court's opinion, and given that, it's on an area of law that I'm not super familiar with, I am pretty comfortable to say, yeah, the court probably got it right. It certainly makes a compelling argument. And I think the strongest part of the argument to me is just, well, you've got these other exceptions both in Section 1446 and elsewhere, referring to Section 1446 in other provisions, that, make exceptions to the 30-day deadline, taking into account equitable considerations and whatnot. And those exceptions would be completely superfluous if broader equitable tolling were allowed in Section 1446b1, right? Like, basically, if equitable tolling is allowed for this 30-day deadline in specific circumstances, that's completely superfluous and pointless if it's also just allowed in general in, any other context. So, yeah, when Congress is making an enumerated list of exceptions, courts generally shouldn't read the statute as permitting them to make up new exceptions. Sounds right to me. So, yeah, I don't really have all that much more to say about this, other than, once again, I really wish Sotomayor would find another way to refer to the statutory provision other than, Section 1446b1, because it's really annoying to read it out every time, but whatever. It's not really an issue if you're just, writing it and reading it off the page as opposed to, reading it aloud. It's just a mild gripe that I have and will continue to have. Actually, one last thing that I would like to say, that has nothing to do with the, legal merits and not really much to do with the opinion itself, but just the, factual circumstances underlying this case. It's kind of fucked up to me that the state of Michigan is, trying to screw up this, international and, seemingly pretty important oil pipeline. It's like, you've got a single state that this pipeline happens to run through, concerned over a specific 4-mile section of an over 600-mile pipeline that's supplying oil to, significant parts of Canada and the Midwestern United States. That's like, actually, we're concerned about, that the oil might spill on this 4-mile stretch at some point ever. So we're going to shut the whole thing down, actually. And it's like, no, it's like, I mean, again, nothing to do with the legal merits of the case, but just for practical purposes, that is really screwed up to me. And, it just strikes me as really stupid because, as I understand it, pipelines are the safest way to transport oil for long distances. And I don't know, it's just kind of one of those things. It seems like, oil pipelines and AI data centers and nuclear power and such, where people just get up in arms and politically engaged over these specific things that they have been somehow convinced are just the devil's work for seemingly no reason. But is somehow, somehow people get it in their minds that this is bad, and then God forbid you build one ever. Um, now nuclear plants have to be shut down because they're dangerous, and Chernobyl and whatever, and data centers use up all the water and all the electricity ever. spoiler, no, they don't. Oil pipelines will spill even though they're like the safest way to do long range oil transportation. It's just, yeah. And so we have to like stop this up for everybody else because, we're concerned about this single 4 mile stretch or whatever. And not only that, but it's like implicating treaty obligations, apparently. A single state, like, throwing a wrench in the United States' treaty obligations to, you know, one of its neighbors. I don't know, it just sucks. And, for practical purposes, that's why it kind of sucks that, like, this has to go back to the state court. And the court is, again, it's correct. It has to go back to state court. There's no getting around that. But it really sucks because Michigan state courts are, going to be a hell of a lot more likely to allow the state to throw a wrench in this than federal courts would, which I think the state of Michigan knows, which is why the governor immediately dismissed her lawsuit when the federal courts were like, "No, we're keeping this one. Like, this is the proper forum for it because in part of these treaty obligations actually." Um, now maybe the Michigan courts won't let the state throw a wrench in things and won't let the state's lawsuit prevail, but if any court would, between the state and federal courts, it'd be the state courts. So, sucks, but whatever. But with that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. We may be doing some bonus content that is something other than reading a Supreme Court opinion here pretty soon. With that, thank you for listening, and tune in for the next episode where we will continue on through the Supreme Court's 2025 term. Until then.